Hello friends, welcome to Law and GK. So friends, on this channel we discuss the contents of law and previous year papers of judicial services and other legal exams. So friends, as you know कि हमने उड़ीसा जुडिशियल सर्विसेज के जितने भी पेपर हमें मिले हैं अभी तक फ्रॉम 2011 टू 2020-21 वो पूरे डिस्कस कर लिए हैं ऑलरेडी. एंड आज की इस वीडियो में हम करने जा रहे हैं ऑल द क्वेश्चंस ऑफ IPC ऑफ द उड़ीसा जुडिशियल सर्विसेज. सो फ्रेंड्स, इफ़ यू आर न्यू ऑन दिस चैनल आई वुड लाइक टू रिकमेंड कि आप जो है इस चैनल को जल्दी से सब्सक्राइब कर लीजिए बिकॉज इट विल बी वेरी बेनिफिशियल फॉर यू इन प्रिपरेशन फॉर जुडिशरी एंड अदर लीगल एग्जाम्स. And while subscribing, don't forget to press the bell icon so that you can get the notification for our upcoming videos. And if you like this video, just click the like button over there and appreciate this with your friends so that they can come to know about this channel as well. And अगर आपको हमारे efforts अच्छे लगे हों तो in addition to like and subscribe, kindly give us a super thanks. Super thanks is a way to help the content creator. Means if you like the videos, you can just donate some money to them in form of tips. Minimum starts with 20. Minimum is 20 rupees. So question number 1 is, under the IPC, abatement is constituted by instigating a person to commit an offence by engaging conspiracy, intentionally aiding. All of the above. ये repeat question है, पहले भी आ चुका है उड़ीसा सीरीज में ही. डी इसका आंसर रहेगा. कहाँ पर है ये? सेक्शन है 107 IPC. Next is 2. The distinction between section 299-300 was made clear by Justice Melville in R versus Govinda. C is the answer. Next is 3. Which section deals with dowry death? That is 304B IPC. D is the answer. Next is 4. Grievous hurt means emasculation, disfiguration, any hurt which endangers life. All of the above. D is the answer. कहाँ डिफाइन किया गया? सेक्शन 320 IPC में. Next is 5. Whoever voluntarily obstructs any person has to prevent that person from proceeding in any direction in which that person has right to proceed. That is wrongful restraint. C is the answer. सेक्शन कौन सा है? 339. डिफॉर्मेशन कितने में? 499 में. फोर्स कितने में है? 349 में. एंड wrongful confinement कितने में है? 340 में. C इसका आंसर रहेगा. Next is 6. Whoever by force, compel or by any deceitful means induces any person to go from any place, that is abduction. A is the answer. सेक्शन 362. किडनैपिंग कहाँ पर है? 359 डेफिनेशन किडनैपिंग की. फिर उसमें फ्रॉम इंडिया है 360 में एंड लॉफुल गार्जियन 361 में. हैबिचुअली डीलिंग इन स्लेव्स है स्लेवरी पे सेक्शन 371 है ये. फोर्स लेबर का है 374. अनलॉफुल कंपल्सरी लेबर. 35. Actus me invito. Factus non est means act done by me against my will is not my act at all. B is the answer. और ये सेक्शन 94 पे अप्लाई होती है IPC में. Next 36. Robbery is an aggravated form of theft or extortion. Both. C is the answer. Next 37. Who may be said to be of unsound mind? An idiot, a madman, one who is drunk. All of the above. इसमें रहेगा एन इडियट. ए इज द आंसर. जो ड्रंक है वो कौन होता है? वो इंटॉक्सिकेटिंग. ओके. 38. When two or more person by fighting in public place disturb the public peace is called as affray. A is the answer. सेक्शन कौन सा है ये? 159. रॉयटिंग कितने में? 146 में. असॉल्ट कितने में? 351 में. कर्फ्यू कहाँ लगाते हैं? 144 सेक्शन CRPC में लगता है ये तीनों है IPC. Next 41. Fraudulently has been defined as doing anything with intent to defraud. सेक्शन कौन सा है? देखिए मैंने इसका ही बनाया हुआ है MWDF 22, 23, 24, 25. तो F25 में आ गया. B is the answer. 23 में क्या है? wrongful gain, wrongful loss. ठीक है. 24 में क्या है? dishonestly. 22 क्या है? movable property. 26 क्या है? reason to believe. Next 42. सेक्शन 34 IPC creates a substantive offence या फिर rule of evidence. It is only a rule of evidence. substantive offence नहीं है. B is the answer. वो substantive offence अगर इसमें कंपैरिजन करें 149 से तो 149 है substantive offence. B इसका आंसर रहेगा. Next 43. The maxim ignorantia juris non exequisat. तो ignorance of law is no excuse. ए इज द आंसर। सेक्शन 76 एंड 79 में अप्लाई होती है मैक्सिम। नेक्स्ट 44 सेक्शन 84 आईपीसी प्रोवाइड्स फॉर लीगल इंसैनिटी, बी इज द आंसर। मैकनॉटन का केस आता है ना, वर्ल्ड फेमस केस। नेक्स्ट 45 द राइट टू प्राइवेट डिफेंस इज बेस्ड ऑन द नेचुरल इंस्टिंक्ट ऑफ सेल्फ प्रिजर्वेशन, ए इज द आंसर। और प्रोविजन कहाँ से कहाँ तक है? 96 से 106 तक आईपीसी। नेक्स्ट 46 चैप्टर 20 ऑफ आईपीसी डील्स विद, ये है ऑफेंसेस रिलेटेड टू मैरिज, ए इज द आंसर। सेक्शन कहाँ से कहाँ तक है ये है 493 से और 498 तक। डेफेमेशन का चैप्टर है 21, तो ये कहाँ से कहाँ तक है? 499 एंड 500 है। ऑफेंसेस अगेंस्ट प्रॉपर्टी, ये चैप्टर 17, और कहाँ से कहाँ तक है? ये 378 थेफ्ट से स्टार्ट होता है और 462 तक है। नेक्स्ट 47 द एसेंशियल इंग्रेडिएंट ऑफ अ क्राइम इज एक्टस रियस एंड मेंस रिया, सी इज द आंसर। Next 48 in which case Supreme Court held that defense of drunken can be availed of only when intoxication produces such a condition as the accused loses his requisite intention for the offense। तो ये केस था मुबारक हुसैन वर्सेस स्टेट ऑफ राजस्थान, 2007 का केस है। 20 का आंसर रहेगा। नेक्स्ट 49 सेक्स विद अ गर्ल थ्रू forbidden consent amounts to rape, डी इज द आंसर। कंसेंट इज नो कंसेंट इफ इट इज टेकन अंडर मिसकंसेप्शन, कौन सेक्शन में लिखा हुआ है ये सेक्शन 90। नेक्स्ट 50 एवरी मर्डर इज कल्पेबल होमिसाइड बट नॉट वाइस वर्सा, द स्टेटमेंट इज ट्रू, ए इज द आंसर। नेक्स्ट इज 41 अकॉर्डिंग टू डैश a crime is a violation of public rights and duties due to whole community, it is said by Sir William Blackstone, A is the answer। Next 42 crime which do not require intention, recklessness or even negligence as to one or more element in the actus reus is known as strict liability, B is the answer। Next 43 section 304B in chapter 16 of IPC deals with dowry death, C is the answer। ये कितना है? 376। क्रूअल्टी कितने में है? 498 ए में। इंसल्ट द मॉडेस्टी ऑफ द वुमन 509। नेक्स्ट 44 द ऑनरेबल सुप्रीम कोर्ट इन वन ऑफ द फॉलोइंग केसेस हेल्ड दैट जनरल प्रिंसिपल ऑफ क्रिमिनल जस्टिस इज दैट जुडिक्शन इज डिटरमाइंड बाय लोकेलिटी ऑफ द ऑफेंस इररिस्पेक्टिव ऑफ द नेशनैलिटी और एनी सिमिलर एट्रीब्यूट्स ऑफ द ऑफेंडर। तो स्टेट ऑफ वर्सेस एल आफ्टर ये किस पर है? ये डबल जियो पार्टी पर है। जो ये कहा गया सुप्रीम कोर्ट ने कौन से केस में कहा था? ये कहा था मुबारक अली वर्सेस स्टेट ऑफ बॉम्बे में, डी इसका आंसर रहेगा। ऐसे 45 अकॉर्डिंग टू द ऑनरेबल सुप्रीम कोर्ट इफ अ पर्टिकुलर ऑफेंस कैरीज मैंडेटरी सेंटेंस ऑफ इम्प्रिजनमेंट, अ कंपनी कैन नॉट बी प्रोसिक्यूटेड, नो इट कैन बी प्रोसिक्यूटेड, ये हो गया गलत। फिर है कैन बी कन्विक्टेड हाउ एवर कैन नॉट बी इम्प्रिजन, इट कैन बी इन प्रिजन, सेंटेंसिंग हो सकती है कंपनी की, बट उसके लिए कौन जाएगा अंदर? डायरेक्टर जाएंगे, डायरेक्टर्स कैन बी इम्प्रिजनड। तो दिस इज द प्रॉपर आंसर, डी इज द आंसर। सी भी ठीक है, ये कैन बी कन्विक्टेड एंड कैन बी फाइन, फाइन तो लगा ही सकते हैं, कंपनी भरेगी फाइन को। नेक्स्ट इज 46 दे ऑल्सो सर्व हु ओनली स्टैंड्स एंड वेट, दिस ऑब्जर्वेशन फॉर्म्ड पार्ट ऑफ जजमेंट ऑफ ऑनरेबल सुप्रीम कोर्ट इन विच वन ऑफ द फॉलोइंग केसेस। ये बोला गया था जो वीरेंद्र कुमार घोष वर्सेस एम्परर है प्रीवी काउंसिल का, उसमें बोला गया था ये चीज़। और ये जो लाइन है एक्चुअली ये एक पोएम से ली गई है, ओ हिज ब्लाइंडनेस। किसकी पोएम है ये? जॉन मिल्टन की। तो वहाँ से ये लाइन ली गई थी इस जजमेंट में। और जो पांडुरंग वर्सेस स्टेट ऑफ हैदराबाद है उसमें जो है इसका रेफरेंस दिया गया है वीरेंद्र कुमार घोष वाले का, बिकॉज दिस इज ऑल्सो ऑन 34 कॉमन इंटेंशन। तो एग्जैक्ट ये लाइन तो यूज़ नहीं की गई थी, जो इसका अगर आप देखेंगे जजमेंट जो है उसमें एग्जैक्ट लाइन्स नहीं है, बट मीनिंग वही यूज़ किया गया है। तो डी इसका आंसर रहेगा, बाकी ये तीनों केसेस में नहीं है। नेक्स्ट 47 सेक्शन 377 आईपीसी प्रोवाइड्स फॉर अननेचुरल ऑफेंसेस, डी इसका आंसर रहेगा। रॉबरी कितने में? 390 में, पब्लिक न्यूसेंस 268, थेफ्ट 378। फिर है 48 क्वी फेसेट पर एलियम फेसेट पर से होना चाहिए। द एसेंस ऑफ दी वन ऑफ द फॉलोइंग प्रिंसिपल्स ऑफ क्रिमिनल लायबिलिटी, ही हु एक्ट्स टू अनदर एक्ट्स फॉर हिमसेल्फ, तो वो है वाइकेरियस लायबिलिटी का प्रिंसिपल, बी इसका आंसर रहेगा। नेक्स्ट इज 49 in which case the Honorable Supreme Court has struck down mandatory death penalty under 303, that was Mittu versus State of Punjab, D is the answer. Next 50, the two judge bench of Honorable Supreme Court in one of the following case held that long delay by President or Governor in disposing mercy petition for convict under anti-terrorism law or similar status cannot be ground for communication of death penalty into life imprisonment. तो ये केस था पीपल्स यूनियन फॉर डेमोक्रेटिक राइट्स वर्सेस यूनियन ऑफ इंडिया, बी इज द आंसर। उस टाइम पर रिसेंट जजमेंट्स में पूछा गया था केस ये। नेक्स्ट 41, ए बीइंग अ पब्लिक सर्वेंट डायरेक्टली बाय लॉ टू टेक प्रॉपर्टी इन एग्जीक्यूशन इन ऑर्डर टू सेटिस्फाई डिक्री प्रोनाउंस्ड इन बीज फेवर बाय अ कोर्ट ऑफ लॉ नोइंगली डिसओबेज डायरेक्शन ऑफ लॉ विद इन knowledge that he is likely thereby to cause injury to B, A has committed the offence of section 166, A is the answer। और ये उसमें illustration है। Next है 42, which of the following does not form part of actus reus? Thought of conduct, result of conduct, circumstances as are specified by law या फिर conduct। थॉट ऑफ कंडक्ट नहीं रहेगा, ए इज द आंसर। रिजल्ट, कंडक्ट या फिर जो सर्कमस्टांस हुए हैं वो सब रेलेवेंट रहेंगे, पार्ट होंगे एक्टस रियस के। थॉट तो किस में आ जाएगा फिर, इंटेंशन में आ जाएगा। नेक्स्ट इज 43, अंडर विच ऑफ द केसेस कैन अ स्टैट्यूट एक्सक्लूड मेंस रिया? पब्लिक न्यूसेंस में, केसेस इन पब्लिक इंटरेस्ट, यस बोथ, सी इज द आंसर। नेक्स्ट 44, A with a view to murdering D enters D's bedroom at night. When D is out of station, A is guilty of house trespass. A is the answer. Next 45, criminal conspiracy is defined by section 120A. C is the answer. 120B में क्या है इसकी punishment. Next is 46, X meets Z on a national highway, shows a knife and demands money. ये क्या हो गया? And gold ornaments found on the body of Z. दिस इज रॉबरी, डी इज द आंसर। सेक्शन 390 है ये। एक्सटॉर्शन कितने में, 383 में, डकैती 391, थेफ्ट 378। ऐसी 47, डकैती कैन कवर रॉबरी बेस्ड ऑन एक्सटॉर्शन थेफ्ट, बोथ, सी इज द आंसर। ऐसी 48, यूज ऑफ वायलेंस बाय मेंबर ऑफ अनलॉफुल असेंबली इन फर्दरेंस अ कॉमन ऑब्जेक्ट विल कंस्टिट्यूट रॉयटिंग, ए इज द आंसर। सेक्शन कौन सा है, 146। असोल्ट कितना है, 351। एफरे कितने में है, 159 में। नेक्स्ट 49, द डिफेंस ऑफ कंसेंट हैज नो एप्लीकेशन इन केस ऑफ कॉजिंग ग्रीवियस हर्ट, कॉजिंग डेथ, बी इज द आंसर। अगर मान लो कंसेंट से भी डेथ की है तो वो सेक्शन 300 में फॉल करेगा, बट एक्सेप्शन 5 में आ जाएगा, तो क्या होगा फिर, वो कल्पेबल होमिसाइड कहलाएगा। नेक्स्ट 50, द एसेंस ऑफ सेडिशन अंडर इंडियन पिनल कोड इज आर, रिजल्ट या फिर इंटेंशन, बोथ इंटेंशन एंड रिजल्ट, ओनली इंटेंशन, बी इज द आंसर। ये भी देखो कई बार क्वेश्चन आया हुआ है कि क्या जो रिजल्ट है सेडिशन में वो मटेरियल है, नो इट इज़ इमटेरियल। रिजल्ट क्या रहा, वो इमटेरियल है, आपके इंटेंशन को जो है वो पनिश किया जा रहा है। Next 41, knowingly stating a public servant on oath as true that which is false is dealt under section कौन सा IPC, that is section 181, C इसका आंसर रहेगा। Next 42, public servant disobeying instruction of law with intent to save person from punishment of property under forfeiture is dealt now, कौन सा सेक्शन है ये, 217, B इसका आंसर रहेगा। Next 43, escape from confinement negligently suffered by public servant is dealt under 223, D इसका आंसर रहेगा। Next है 44, absconding to avoid service of summons or other proceedings from a public servant is dealt under 172, A is the answer. Next 45, attempt to commit robbery or डकैती when armed with deadly weapons is dealt with 398, A is the answer। 399 में क्या है, प्रिपरेशन फॉर डकैती। 400 में क्या है, belonging gangs of dacoit. 401 belonging gangs of thieves. Next 46, death caused by an act done with the intent to cause miscarriage is dealt under section 314. A is the answer. Next 47, attempt to commit suicide is dealt under 309. 306 में क्या है, abatement to suicide, तो D इसका आंसर रहेगा. नेक्स्ट 48, अबेटिंग द कमीशन ऑफ सुसाइड इज डेल्ट अंडर, अभी बताया देखिए 306. ए इज द आंसर. 307 में क्या है, अटेम्प्ट टू मर्डर. 308 अटेम्प्ट टू कल्पेबल होमिसाइड. 309 अभी बता ही दिया ऊपर. नेक्स्ट 49, थ्रेटनिंग एनी पर्सन टू गिव फॉल्स एविडेंस इज डेल्ट अंडर, दैट इज 195. ए डी इज द आंसर. नेक्स्ट 50, विच ऑफ द फॉलोइंग इज नॉट एन इंग्रेडिएंट ऑफ अबेटमेंट, इंस्टिगेटिंग, एंगेज इन कॉन्स्पिरेसी, इंटेंशनल एड. एंटाइसमेंट नहीं है, डी इसका आंसर रहेगा. नोट पूछा है ना यहाँ पर. नेक्स्ट 41, गुड फेथ इज डिफाइंड इन IPC in section 52. Next 42, maximum punishment for the offense of theft in dwelling house is 7 years. C is the answer. section 380 के अकॉर्डिंग पनिशमेंट मिलेगी. Next 43, which section of IPC based on principle de minimis non correct lax, that is section 95. D is the answer. Next 44, disclosure of identity of victim of rape is dealt under section 228. A. D is the answer. Next 45, the offense of destruction of electronic evidence to prevent its production as an evidence is punishable under section, ये है 204 में, C इसका आंसर रहेगा. Next 46, who prepared the first draft of Indian Penal Code, that was Macaulay. D is the answer. Next 47, under which of the following section of IPC is rash and negligent driving of vehicle on public ways an offense, that is 279. B is the answer. Next 40, in section 497, actus reus relates to married woman. Now this is unconstitutional by the case Joseph Shine versus Union of India with effect from 2018. Next 49, whether provocation was grave and sudden enough to mitigate the offense is a question of fact. It is mentioned in section 300 exception 1. Next 50, when a person monitors the use of internet or other forms of electronic communication by women, he commits the offense of stalking. A is the answer. कहाँ मेंशन किया गया है ये, 354 डी में. वॉयरिज्म कितने में है, 354 सी में. Next is 41, A who knows swimming failed to save the life of a drowning child and a child dies as a result of A's omission. A is liable for not saving the drowning child. No, A is not liable for not saving. B is the answer. उसकी मर्जी बचाए ना बचाए. Next 42, a person who consents suffers no injury is known as voluntary non-fit injuria. C is the answer. Next 43, which is the following section of IPC deals with the right of private defense of the body and property. 97. C is the answer. Next is 44, A instigates B to murder D. B in pursuance to instigation stabs D. D recovers from the wound. So A is guilty of instigating B to commit murder. Yes. A is the answer. And where this is mentioned, it is mentioned in section 108 and this is illustration B. Next 45, obstructing public servant in discharge of public function is an offense punishable under 186. A is the answer. Next is 46, A knowing that B has murdered Z assist B to hide the body with the intention of screening B from punishment. Under which of the following section of IPC can A be punished? 201. B is the answer. Next is 47, a doctor registered as medical practitioner and entitled to practice in homeopathy only prescribed an allopathic medicine to the patient. Patient died. Doctor is guilty of rash and negligent act. A is the answer. Next is 48, CBT is defined in section 405. C is the answer. And 49, in which of the following cases the Supreme Court held that legal And valid marriage is not necessary ingredient to attract 498A. That was Reema Agarwal versus Anupama Agarwal. A is the answer. Next is 50. A makes an attempt to pick the pocket of Z by thrusting his hand into Z's pocket. A fails in the attempt in consequence of Z's having nothing in the pocket. A is guilty under section 511 IPC. A is the answer. This is illustration B of that section. Next 41. The principle of criminal liability, actus non facetium nisi mansitria, means act alone does not amount to guilt. It must be accompanied by a guilty mind. A is the answer. Next 42. A, intending to kill B, shoots at B but only wound him very slightly. On his being taken to the hospital, an ambulance collided with a bus and the B was killed. Here, A is liable for murder. No, A is not liable since the result is too remote an accident in its occurrence. B is the answer. The causal connection has been broken. So he is not liable for murder, only for grievous hurt or attempt to murder. Next 43. Which of the following offense is punishable with death? 305, 364A, 396. All of them, all of these. D is the answer. 364A is kidnapping for ransom. 396 is dacoity with murder. Alright. 305 is abatement of suicide of child or insane. Next 44. For which of the following offense common object is not an essential ingredient? So I think there must be common object. Unlawful assembly, yes. Affray, there is no need for common object. B is the answer. Affray is mentioned in section 159, unlawful assembly 141, writing 146. Next 45. Mr. A, a candidate for Andhra Pradesh Assembly election, distributed mobile phone to some voters and requested their votes in return. Mr. A has committed the offense under which of the following section? 171B. He had given bribe during the election. Next 46. A doctor registered as a medical practitioner and entitled to practice in homeopathy only prescribes an allopathic medicine to the patient. The patient died. The doctor is guilty of death by rash and negligent act. Why? Because he was a homeopathy doctor. He cannot give an allopathy doctor. So it was a rash and negligent act on his behalf. A is the answer. And other options are murder, culpable homicide. No. Next 47. Attempt to commit suicide is an offense punishable under section 309. B is the answer. 306 is abatement to suicide. Next 48. A police officer tortures Z in order to induce Z to confess that he committed a crime. A is guilty of an offense under provision 330. C is the answer, and this is illustration A of that section. Next 49. Who does any act so rashly or negligently as to endanger human life or personal safety of the others shall be punishable with section 336. A is the answer. Next 50. Under IPC, exhibition of an object with intent to insult the modesty of woman is an offense under section 509. C is the answer. Next is 41. Taking property dishonestly from a dead body does not amount to any offense. It is an offense. It is offense of theft. Theft is taking property from a living person. Dead के लिए तो amounts to offense of criminal misappropriation because it is found on a dead person. So C is the answer, and where it is provided? It's provided in section 404 IPC. Next is 42. In which of the following cases did the Supreme Court explain the concept of grave and sudden provocation as a mitigant circumstances, reducing the gravity of the offense from murder to culpable homicide not amounting to murder? This was K.M. Nanavati. C is the answer. Very famous case. If you have seen the movie Rustam of Akshay Kumar, just watch the movie, you will understand this case. Ditto. That is the story of this case. Next is 43. Acts on receiving grave and sudden provocation from Z intentionally causes the death of Y, who is brother of Z. X has committed the offense of murder. Grave and sudden provocation was given by Z. X killed Y, so that is murder. Next is 44. X with the view to murdering Y enters Y's bedroom at night where Y is out of station. X is guilty of house trespass. B is the answer. And suppose, would that be a case if Y is in the house, X enters in the bedroom but does nothing and leaves the house, and even at that time it would only be house trespass. SC 45. In each of the following cases, the Supreme Court of India has struck down Section 303 IPC as unconstitutional. That was Mithu Singh versus State of Punjab. C is the answer. SC 46. The case of R versus Dudley and Stephen is popular for its use as criminal defense of necessity. A is the answer. Section 81 IPC provides for that. Next 47. Which of the following statement is correct in sedition? The consequence is immaterial. A is the answer. Once it does a sedition, whether that commission was successful or not, it is immaterial. Sedition is sedition. But the sedition is now put in abeyance. Abeyance means nobody can arrest on the ground of sedition. This was in case of, this is the case, you can see that SG Vambatkare versus Union of India and Editors Guild of India versus Union of India. This I have already discussed in landmark judgments of 2022. You can see the video. I will mention the link of the landmark judgments in the description of this video. Next is 48. A bullock cart carrying a box of treasure is intercepted by A. The offense of theft is committed by A if and as soon as he seizes the bullock या फिर bullock is made to move by him in his direction. तो जैसे ही bullock cart move कर दिया, as soon as you move the bullock cart, the theft has been committed. And it is mentioned in this question that in his direction. His direction is not necessary. In any direction he moves. Option C is wrong, D is wrong. Next is 49. A obtains a sum of rupees 10,000 from B by putting B in fear of death. Which of the following offense is committed by A? A has committed extortion. See, it is not mentioned whether the fear of death was instant या फिर distant. So we assume that there is no instant fear, so it is extortion. D is the answer. If it is mentioned that in instant fear of death, that would be robbery. Extortion is provided in section 383. Cheating कहाँ पर है? 415. Robbery 390. Mischief 425. Next 50. Use of violence by member of assembly of 5 or more person in furtherance of common object will constitute rioting. C is the answer. Some people would be thinking that it is unlawful assembly. See, it is mentioned use of violence. If this use of violence is not mentioned, then it will be unlawful assembly only. Where rioting is provided, it is provided in section 146, assault 351, affray 159, unlawful assembly definition 141. So friends, here we have discussed all the questions of IPC from the year 2011 to 2021 of the Odisha Judicial Services. अगर आपको इसमें कोई कमी लगी हो, कोई सजेशंस और एडवाइस हो, तो आप कमेंट सेक्शन में जाकर भी लिख सकते हैं. We always appreciate your comments and feedback. And friends, if you like the efforts, kindly give a super thanks. Super thanks is a way to help the content creator. Means if you like the videos, you can just donate some money to them in form of tips. Minimum starts with 20. Minimum is 20 rupees. And अगर आपको वीडियो अच्छी लगी, इसको जरूर लाइक कीजिएगा. And don't forget to subscribe our channel. And while subscribing, don't forget to press the bell icon so that you can get the notification of our upcoming videos. So friends, thank you. Thanks very much for watching this video. Thank you.